For example, as I put up on the slide here, it's a condition of this contract that X delivers the goods in sealed boxes, and only upon such delivery is payment due from Y. As against, X shall deliver the goods in sealed boxes, and Y's payment for the goods is conditional upon such delivery of the goods by X. Do those clauses have the same consequences if X fails to deliver the goods in sealed boxes? No. The first formulation gives Y the right to terminate and to claim damages for loss of bargain. The second gives Y no right to terminate and only gives Y the right to claim for ordinary damages. So, in summary, providing in the contract that any breach of contract would give rise to a right of termination is risky, because the courts may well decide that such a provision is contrary to business common sense. Going through the contract to decide which provisions should be classified as conditions and which not is not usually the favoured route and can have unintended consequences. So what are the alternatives? The most common contractual provision is a right of termination for a material breach of contract. What's a material breach? It's not just a repudiatory breach. A repudiatory breach is a breach of contract that's so serious that the innocent party has the right to terminate the contract as a matter of common law. So if your contract contains no termination clause at all, then a party should still be able to terminate if there's a repudiatory breach. A material breach is a breach that has a serious effect on the benefit that the innocent party would otherwise derive from the performance of the contract in accordance with its terms, without necessarily amounting to a repudiatory breach. The materiality of the breach will depend on all the circumstances, including the terms and duration of the contract, the nature of the breach, and the consequences of the breach. So what the parties do is elevate the role of a material breach by attaching an express right of termination in the event that such a material breach occurs. And you can immediately see the advantages of doing this. There's no need to classify contract clauses as conditions or otherwise. A flexible mechanism is built into the contract which allows the gravity of the situation that arises to be assessed in all circumstances. However, one party's flexibility is clearly another party's uncertainty, because what is a material breach in any given situation may ultimately need to be decided by the courts, and the courts themselves will sometimes express different and conflicting views. In Dalkia Utility Services and Celtec, the court regarded a material breach as one to be assessed by looking at the nature of the breach. So, for example, it would exclude not only a minimal or inconsequential breach, but also an accidental or inadvertent breach, even when the consequences of that accidental or inadvertent breach were not minimal or inconsequential for the innocent party. Material breach in that case being determined primarily by the nature of the breach and not the consequences for the innocent party. But in National Power and United Gas Company, the court took a different view and said that a material breach was one which, quote, in all the circumstances is wholly or partly remediable and is, or if not remedied, is likely to become serious, in the wide sense of having a serious effect on the benefit which the innocent party would otherwise derive from the performance of the contract in accordance with its terms. National Power, I think, is generally regarded as the preferred case. Nevertheless, best practice therefore suggests that you should include a right to terminate for material breach in the contract, but also provide an express right of termination for breach of certain specific performance obligations in order to avoid the uncertainty inherent in the use of the expression material breach alone. Those performance obligations would of course include the key performance obligations under the contract, but might also include, for example, repeated breaches, where any one breach on its own may not be regarded as material, but where the cumulative effect is prejudicial to the innocent party. Once a breach entitling the innocent party to terminate has occurred, the innocent party must elect either to affirm the contract and continue performance, or to terminate and claim damages. The innocent party has some timing leeway in that its decision can only be made once it's fully aware of all the facts surrounding the alleged breach, but nevertheless it does have to make a decision, and in the Tele2 case in 2009, the Court of Appeal held that, notwithstanding a no waiver clause in the contract, the innocent party, by delaying for 12 months, had affirmed the contract by conduct, thereby waiving its right to terminate. The court held that whether an election has been made is a question of fact, and it can't be trumped by a no waiver clause in the contract. So, in conclusion, what is meant by termination for insolvency and termination for a material breach should be defined in the contract, and the consequences of termination should also be addressed and, where appropriate, commercially justified in the contract. But we're now going to move into the Q&A part of our session. We've been monitoring the questions that have been coming in during the presentations, and the first question is one for Vanessa, going back to the types of loss that we were looking at, which is whether you can actually claim, Vanessa, for both expectation and reliance loss. You talked about the two types of loss, but are they running together or are they effectively running separately?
No, it's a good question. They're actually mutually exclusive to effectively prevent double recovery, and in that sense you can't claim for both loss of profits and both expectation and reliance loss effectively. And I think the key there is really to say, if the parties are expecting certain things in the contract or the contract to be performed in a certain way, and that if there is to be a breach, then I think the parties should certainly draft in the contract what they're expecting to recover and what they're expecting to see, rather than effectively leaving it up to chance or leaving it up to the courts to decide.
Yeah, because as that question came in, you and I were actually sort of just discussing offline whether you could draft into the contract something which would assist in that respect. And we had sort of slightly different opinions, because presumably your basic test is still direct loss or indirect loss, with indirect loss quite often being the loss which parties exclude, which is the one which says, in any event within the contemplation of the parties. So in a sense, drafting that into the contract, but then excluding indirect loss sort of doesn't take you further forward.
I think there are certain, if you're expecting sort of to recover loss, I don't know, for anticipated profits, or I don't know, for reputational loss or something like that, for a specific contract, and you are expecting to recover for that, then I think you should actually put that into the draft.
Yeah, and at the end of the day, it certainly can't hurt, can it? I mean, you can't offhand anyway make the position any worse. There was actually a related question which came from you on this, Peter. There's obviously quite an interesting aspect of the presentation, which was how are damages measured in a BPO contract? Are you looking at the same principles? Are you looking at the same types of loss that Vanessa was discussing generally?
Well, you are. A BPO, so business process outsourcing contract, where we might be looking at, I don't know, anything from sort of HR, outsourcing of HR services, finance and accounting, other back office services. I mean, it will be treated like any other commercial contract, and all the principles Vanessa has been talking about will apply equally to that type of situation as well. But I think the interesting thing about BPO contracts is that quite often the parties, or the customer, is certainly going into the BPO contract on the basis of cost savings, and perhaps more so than in other sorts of outsourcing arrangements, it'll be the cost savings generated by the supplier over time. That's really what they're looking for in terms of comparing that to what they might have been, what it might have cost for those services to be performed internally. Now, in the event of a breach or in the event of something going wrong under that relationship, how easy is it then for the customer to try and claim for perhaps the lost benefit, if you like, of those cost savings? And and that may well come down to how those liability provisions are drafted. As we were just saying a minute ago, around forms of indirect loss are included within the scope of what might be claimed, or loss of profit. That the drafting will be critical in terms of, particularly in terms of the liability under an outsourcing arrangement, whether it's a BPO or any other form of outsourcing arrangement.
Yeah, and which actually takes us on to another question which came in. A BPO contract is obviously one contract where you might typically see service credits that you were talking about previously.
Yeah.
When you're looking at service credits as a non-exclusive remedy, what are the advantages of doing that? I mean, you went into that briefly in any event. But if you could expand on that, and then maybe take that on to how will you then actually draft for that non-exclusive remedy?
Well, the second point first, so it needs to be very clear that it is a non-exclusive remedy, obviously, but the advantages from the customer's point of view are obviously that they can claim for the agreed payment is made, the service credit is payable when the service level isn't achieved, so that's getting the supplier's attention in relation to those particular service levels and hitting those service levels. But in the worst case scenario of a catastrophic breach or a catastrophic failure, then the customer isn't restricted to claiming those service credits. They can also claim their damages, common law, or under the contract more generally. So in drafting for that, it needs to be quite clear that it is a non-exclusive remedy, that the customer will have the ability to claim its additional losses. So you would be saying, wording effectively, without limitation, without restriction of customers' other rights and remedies and so on. the service creditors payable. So making it clear that the customer can use its other rights, both at common law and under the contract, when something goes wrong. And that's most likely when something goes very badly wrong.
Great. Thanks for that. I think we've just got 1 minute left, so there's just probably time to squeeze one more question in, Peter. It's a slightly left field one which has come in for you, which is not something that we touched in the presentation. But where you've got in a contract a right of termination, but against that a termination payment is to be made, how does the liquidated damages and penalties impact on that?
Well, yeah, I mean, in that situation, it's quite common, obviously, in an outsourcing arrangement in particular, that there would be a right of early termination or termination for convenience, or a break clause, or however it may be described. But in order to be able to exercise that right, a payment is typically going to have to be made. Now, in that situation, there isn't really a breach as such. I mean, the parties have agreed that the contract can be ended early, subject to a payment being made. I think it's worth, though, keeping in mind some of the principles I talked about in terms of making sure there is some documentation around how the calculation of what is payable is made, just in case it is challenged as a liquidated damages provision that is in fact a penalty. But my instinct on that situation is that there is actually no breach, and it's simply an agreement to make a payment for a right that exists under the contract, which is to actually end the contract early.
Great. So we can end on a high note. We can sleep easy on that one.
I hope so. I hope so, Jonas.
Thanks very much. Well, we'll close our Q&A session at this point. The PowerPoints that have been on your screens during the presentations will be emailed to all participants after we close. For those lawyers who stayed the course, thank you very much. I'm pleased to say that the webinar is accredited and qualifies for 1 hour CPD. Our SRA accreditation code is on your screens at the moment. Will also be in the slides, obviously, when they're emailed to you. Our next SmartLaw webinar will be our annual commercial law update, which looks back at the key legal developments of 2012, and we'll be holding that in early January next year, and of course we'll send around the details of that event in due course. So I'd like to thank you all very much for participating